Last time, as Ryan said, it was about private equity. But one of the things that came out of that was a discussion with one of our panelists, Craig Weiss. Many of you know Craig. Craig is the founder of Enjoy. He's also the founder of Aladdin and Retainer Club. And Craig, in his former life, was a patent attorney. And we got in this discussion about the value of a patent. And Craig, being a patent attorney, I just happened to ask him, like, Craig, what do you think now is the value of patents, and do we need them? And he was adamant about it and said, look, patents are basically useless. And this comes from a patent attorney, by the way. Patents are basically useless because, look, if Google loses its patent, I'm still going to Google it. And he said, what has become more and more valuable is your trade name and how that's perceived in the marketplace. And if you can have a land grab or you build brand recognition in your brand, people will become loyal to you and you won't really need the patent. So patents have, per Craig, he believes that patents don't have the currency that they once did. So this panel, we're going to examine the wreckage of patents. Do we need them? Do we not need them? If we do, then when? What else can we use in replacement of a patent? Canyon 49, I'm sorry, not Canyon 49. State 49 was here, and they talked about their copyright. One of the questions I didn't get to ask them was that how many violations have they had about their copyright, and how do they defend that? So with us today, we have a panel here. I'm going to ask them to introduce themselves. Len, we'll start with you. Can you give your name, where you're from, what you do?
Hi, my name is Len Smith. I'm from here in Scottsdale. I'm an attorney. I've practiced for about going on 25 years now. I grew up as a patent attorney mostly. I spent about 1/3 of my career also in licensing, M&A. I spent 1/3 of my career doing litigation. My most recent stops for the last 2 years, I've owned my own firm. It's called Transformative Legal. Before that, I was with Medicis, which is one of, I think, the best exit stories of the Valley. Very successful run. We were acquired by Valiant. I was one of the few people who was picked up by Valiant. While I was there, I helped buy Bausch & Lomb, amongst other things. So I've litigated patents all over the world. Before that, I was with Novo Nordisk. If people know healthcare, it's one of the biggest biotechnology companies in the world. So I've seen models from all kinds of places, and today I deal with all kinds of clients on the patent space. So I look forward to a discussion, and we get back to it. I'll give a response to Craig if he's here. So
thank you. Michelle.
Sure. Hi, everyone. Michelle Eichner. I'm a B2B SaaS veteran who's gone through many different iterations of different softwares over the last 20 years. I started a B2B SaaS enterprise software in 2003 with a successful exit in 2010. And I recently started another software company in that's really revolutionizing file search in the workplace with a universal file search engine that makes it very easy for you to find your file because it goes across all your cloud platforms and gives you a very quick way to find your files without disrupting your current tech stack. And so I'm probably on this panel in part because I've had a variety of different software, that I've worked for different software companies, and I've started a couple, and I've gone down the path of doing patents and deciding whether or not we should or shouldn't do patent in our current environment.
Yeah, and can you tell a little bit about Digitile right now? Recent success, recent awards, and the like?
Sure. So we got started in the last year. We've won the Arizona Innovation Challenge by the Arizona Commerce Authority, so we were very happy to have that, and we're involved in their accelerator program as of now. We've won Venture Madness and been a part of that. We've got a variety of customers across the U.S. and, frankly, outside the U.S., so we've been building our traction on helping you all find files much quicker at work.
Thank you. Josh?
Josh Topel, co-founder and head of product at Digitile. I have to ask, how many of you struggle or think that you struggle to find files on every day? Okay. I'm not going to go through everything that she talked about or our business, but in a nutshell, 86% of people say that they struggle to find files every day. So my background is actually previously I was at IBM. I was a sales engineer. I spent my time selling marketing automation software into Fortune 500 companies. While I was at IBM, the culture there is heavily predicated around patents. Fun fact for you, IBM leads the world in 9,100 patents as of the beginning of this year. It's crazy. They're treated like rock stars. And so I'll give a little experience on that in this conversation. And thank you for having me.
Thanks, Josh. Danielle?
Hello, my name's Danielle Janitch, and I'm an attorney here in town at a firm called Osborn, Maledon. My background started out in biochemistry, and from there I went into the military active duty for about 5 years, and finally went to law school. After law school, I litigated, doing general commercial litigation, and sort of slowly transitioned into doing, more by serendipity than anything, counseling to help clients thinking about bringing their products to market. So I do a lot of early stage and early growth companies thinking about how best to take their idea, their intellectual property, protect it, and then commercialize it. I'm not a patent attorney, so we'll defer to Lynn on some of those questions, but I help with complex patent licensing, trade secret protection, do a lot of trademark works, a lot of data privacy and security work, and copyright work.
Which branch of the military serving?
I was in the Army, and I was in the Medical Service Corps. Are there any other vets in the room? Yeah, there's at least 2 of you. Great, or 3, okay. And I know there's somebody who cared about my health that was here last time, so that was good. So.
Len, let's answer the question. Craig says it's not useful anymore.
Yeah. So has anyone in the audience read the Google story?
Yes.
So if you read the Google story, which is kind of the unofficial biography of Google, you'll know that the author spends about a third of the time talking about, or a quarter of the time talking about, the patents that they had. So this is the point. Does Google need a patent? No. In fact, it may surprise you to find out, but Google is probably the #1 funder of anti-patent legislation in the United States because Google doesn't need a patent anymore, right? They have a massive monopoly. So Google is very much all about taking away patents because patents are about helping really small companies and medium-sized companies. I'm not saying that a patent is useful in every instance. I think this is the big point, what we talked about kind of preparing for this, is there's just a ton of myths about these things. So even talking about a patent, at a rough level, without getting into it, is a little like trying to characterize a car or a house. If you've been to any less developed countries, you might not trade the house that you live in today for those houses, but yet they are both houses. And patents are a little like that too. Not all industries are going to have a place where a patent makes sense. If I was opening up my own fancy chicken restaurant, and I thought I had great service and a unique market value, if I thought I had a Zappos, right, where I had a culture that was unique, undefinable, but I could build that into a brand, I don't need a patent for that. If you're in pharma, medical devices, or anything with a long lead time, right, long development time, real infrastructure, and here's the other trick, it's copyable, right? It's not something that you think is super unique that you yourself can hold on to. If it's copyable, this is probably the main thing that you need it for. The second thing is if you're in those industries, it just turns out to be that this is the asset that you need for doing deals usually. So if you're going to raise money, you're going to license your technology, you need some basis to do it. Now, patents are not the only basis. They could be copyrights, they could be trademarks, and they could be trade secrets, and I know that that's part of what we'll talk about today. But of those, patents tend to be, in those long-lived industries, the best defined and the broadest of those assets.
Okay, great. So let's just frame that. So let's say you're a software company out here. We heard from Aaron. He said that a lot of his software has become obsolete. When do you use, I mean, you framed it pretty well, but let's say it's a software that's probably going to be obsolete in, let's say, 2 years. Do you file a patent?
So we were just having this discussion amongst ourselves. So I think it would be great if my colleague here jumps in too, because I know she's got some opinions on this. And again, I make my money doing this, right? So I file a lot of
disclosure, by the way.
I file a lot of patents. I help people license a lot of patents. I used to sue a lot of people over patents. They've been a big part of my life for 25 years. So I'm a fan. That being said, again, if I'm a software entrepreneur and my life cycle is 1 to 2 years, probably the wrong IP protection strategy for you. Typically, we're talking 3 to 5 years to get these things. And then you've got to go through the process of litigating. Well, guess what? Tack on another 3 to 5 years on top of that. And big bucks, okay? There should be no illusions about the fact that this is not a cheap process, especially when you're a startup and especially when you're bootstrapping. I'm not telling you it can't be worth it. It can.
But if you're going that fast, I don't think it's a good model for you. Does Google still file patents? You betcha. Does Microsoft file patents? You betcha. IBM files crazy patents. So I have some strong opinions about IBM because they are actually the anathema of, to me, of what good patenting is about. Because although they're the number one, and by the way, they've been the number one for like over a decade, and it's a corporate mandate to be number one. At least that's what the people who tell me in the patent department over there. And don't get me wrong, some of the people, like Manny Schechter at IBM, he's a genius, guy's smart, he's conscientious thought. But the day-to-day worker folks doing a lot of this stuff down there, they'll tell me they'll file kind of on anything, and they have it as a fixed-fee commodity model. $6,000, $7,000 for these patent applications. There's really not a lot of thought given to it. From a guy who's seen the rise and fall of products on this stuff, give me a $30,000 or $40,000 good patent that we're going to win on any day over $106,000 crappy patents. I don't want that. It's a loser and it's a waste of money. So it's a game. But what it goes to show you is, right, these things have currency in lots of ways, right? IBM uses them because in software we've got a pool, we've got a trade, and it's also cachet, right? IBM does it for the cachet. We're the most innovative company in the world. How are we going to measure that, right? Completely. This is how we do it. But I think you have real experience with this, and I think people out here would probably benefit from your thoughts. Michelle?
Yeah, so of the two companies I've started, the first one we had a interesting technology in the email deliverability space, which we filed a patent for. It was a lengthy process, relatively expensive. We bootstrapped that business. We were very successful quickly. We didn't need any funding, and probably didn't know any better in some respects as far as the benefits, as far as why we should or shouldn't. It was probably more an expectation that we had something and we felt, okay, this will give our company some value. And the currency in our case was we knew at some point in the future we'd probably sell the organization and felt that that would be a part of the value of the organization when we went to sell. To be frank, I don't think it actually helped or hurt. It certainly didn't hurt the sale, but it wasn't what made or break the opportunity and who acquired us. We got acquired because we were great technology, we had great service, delivered a really good product, and by the way, it had a piece of it, just a small component of it, had a patent, but that business wasn't acquired as a result of having a patent. Our new business, Digitile, this universal file search engine, also has an aspect of it where and I'll let Josh talk about the product side of it, where we could patent it, but we've sat back and said, okay, where are we? This business moves really fast. Technology moves incredibly fast. And I'll let Josh dive into this because this is where we sit here and have debates, because at the same time, investors, certainly angel investors, certain types of investors look at you and say, well, what's patentable? What's your defense in this business? And part of the defense, certainly can lie in a patent, but there's other ways to build defense about a business if you have a good business. And I'll let Josh talk a little bit about kind of some of the debates and where we are and what we've thought about as far as filing and why we haven't.
Yeah. So to give you a little background on what we have the opportunity to patent is we're in a unique situation where we're bringing your desktop files and we marry it with your cloud files across everywhere that they live. And so through that, we have an indexing process where we can index both your local and your cloud. Now, again, to Michelle's point, we've gone back and forth on, do we go, and even to Len's point, do we go spend the time, do we put in the hours of applying, documenting, putting all this together while we're still building a company and a business model, which we're trying to still prove out as we grow. And if you look at the amount of time and the years scaling that out, we could be having a totally different conversation. And what is the benefit or what are the negatives to going through that process? And so we're still actively having that debate. And I can tell you at the moment, we haven't done anything about it. And that's because we're choosing to actually innovate the product, grow the business, which in the long term is what we think is the most beneficial play for us. That could change, but.
Yeah, as a startup, do you actually, if someone violates your patent or the patent you had, do you have the money to actually defend it? So are you going to, if an investor asks you, do you have a patent, you should probably ask them, we'll file your patent, but we'd like you to give us the money if it gets violated, because we don't have the money to defend it. Let's talk about something different. Go ahead.
I wanted to pick something up on what you just said about how we've decided not to pursue the patent and we're moving forward. What steps have you put in place to protect the intellectual property in this interim when you haven't made a decision yet about whether you're going to move forward and keep it as a patent or treat it as something else? What are you guys doing internally to protect it?
So one of the things that we looked at is really the provisional patent.
Okay.
But there's pros and cons in my opinion, and it'd be great to hear Len's opinion as far as the provisional patent, because a provisional patent buys us some time, but at the end of the day, it's not searchable, so who knows you have it?
Right.
What value does it provide us? Other than probably letting us spin some cycles and some
Say we have
precious
one product.
time as far as going down that path. So, unless I'm missing something, fill us in on if there's a magic about and benefit behind provisional patents.
Yeah, no, you hit it on the head, which is again, the provisional is there for buying time. So it's in an industry where you have, again, a long development time, right? Again, pharma is a good example. So in pharma, when you develop a product, you're looking at 7 years on average before that product hits the market. You're going to go through several stages of clinical trials. Then you're going to go for a very prolonged FDA approval process. Provisional is great for pharma because, again, they want to buy time and they want to perfect things. And it's a decision of, are they going to get scooped or not, right? That's the other thing about filing. So you said something really interesting, Josh, and we talked about timing. It's really important. So I want to respond to 3 things real quick. One is, we're going to develop the product before, by the way, great. A good patent attorney, I think, or a good attorney, and I'm sure my colleague down there in the field can, speak to this too. We want people to be thoughtful, right? A thoughtful client is a good client. So we don't want people, again, to walk up and just go, oh, we're just going to do this, and they haven't thought it through. The second thing is, we talked about myths, et cetera, and I'll be the first one to tell you, I was chief business officer for a company owned by the Mars family for 3 years. So I've been in the sales and BD side of the business. I get that. And by the way, nothing is more important than revenue, right? Revenue is lifeblood of a company. And if you're not getting revenue, right, you better be on the path to getting it, right? That comes above everything else. And I can tell you from 25 years of practicing law that law is a really poor substitute for money. Now, it's something, right? It's something. I got a lawsuit. That's something. And trust me, sometimes that's a lot of value. But if I was given the choice between the two, and I didn't, have to fear that lawsuit, I'll take the money any day, right? Because you got to go claw that money back. But again, sometimes there is a suit, and sometimes there's a model. So responding to the question, who's going to fund this litigation? Well, the thing we talked about in our prep call is, the beauty is of course, business will find a way where there is money, right? And so today we have the rise of litigation financing. This, if you haven't seen it, is kind of the hot field coming out of the law lately. I know you have some experience with it too, with a colleague who's doing it. And again, it's exactly for this reason. Litigation is big bucks. Patent litigation, easy $5 million, sometimes 10. Big bucks. You're not going to do that, right, when you're scrapping it out. You're going to need a partner to do it. And luckily, there are now more and more organizations who are willing to hop in and do it. Do they take a cut? Sure. But again, it depends what your goal is from that litigation. So there are some options for people. I'm sorry, I kind of wandered all over the place, but
Well, what I was trying to get at, and I think that's a very good point, it is becoming easier to address your question about what are you going to do to fund your litigation. I think there are alternatives. If you have a good patent and you have a good claim. If you don't have a good patent, you're never going to find any attorney to help you, and you're going to be in the same spot as before. But it is becoming easier. But what I was trying to drive at was when one of the mistakes that I see early entrepreneurs make is that they don't spend enough time on the front end thinking about what is my core intellectual property and how am I properly documenting my protection mechanisms around that intellectual property. Your point that you ran out and you got a patent for your first company is very common. I hear that a lot. They come to us and for counseling after they've already filed a patent with someone else, and now they're realizing it's not quite doing what they thought it should do for them, and what are some of the other strategies that we should think about. And that's what I was trying to drill in. It's great you have a provisional because that does do some security for you, but I was wondering, what are you thinking about on how you protect from your own employees and your contractors and other people that are coming into contact with that intellectual property before you make a decision about whether or not you're going to pursue a patent, or you're going to go down a trade secret route? Are you going to rely on copyrights? How are you going to fully implement that within your organization? And I think having that kind of a discussion with a good counselor, which could be an attorney or it could be an IP asset type counselor. There's multiple professionals that will do that. Is something that you should be doing as you go out and you launch your business, so that you make the right choice. Because Lynn started out saying, it really matters what sector you're in. If you're in healthcare, if you're in drugs, you need a patent. If you're in software, I don't think you need a patent that much at all. And in fact, it might be better to do some other mechanisms of protection. And there's ways that you can do that early on that are relatively inexpensive, driven both in your organization, and they set your DNA of your organization up from the start to have the right type of protection and the right type of mentality that will help you later down the road get investors and also have a better exit, a better valuation. Not just for IP protection, but I think in today's society, it's outside the scope of the panel, but it's a place I play a lot in thinking about what you're doing with respect to data protection, and personal data that you're maintaining.
Can we dive into that a little bit more?
Let's dive into that, because what we're talking about here is trade secrets, right? We want to make sure that you have a mechanism to, because that trade secret has currency, or else you wouldn't protect it, right? So the trade secret, so can you replace your patent, or can you make the trade secret as valuable as your patent, and how?
Yeah, so a question I have for the two attorneys is, obviously there's NDAs from, you talked a little bit about how do you protect yourself from your employees, and putting together a good, tight NDA. What other suggestions the two of you, Danielle, you're talking about? You're getting to some very specific things. Perhaps you can help bring together some very specific things that we could all learn from you.
Yeah, well, NDAs is a whole nother thing we shouldn't lose track of, because when you talk about myths and problems, when Lynn was talking about it, I feel like NDAs is a big one. That was going to be my myth. So talking about trade secret protection is thinking about some very simple things. Putting in place a mechanism where your contractors and your employees that need to have access to the trade secret are aware that they're having access to something that you think is a trade secret, having a list of your trade secrets so people know what they are. A lot of times employees don't realize something you think is a trade secret might even be a trade secret because you haven't properly documented it. You haven't put that knowledge in front of them. And so one of the things that we often counsel people to do, and you're from IBM, so you're going to know the process that they have for when you have a new invention and you go and you disclose it and you start the patent process. You can use a very similar type of disclosure and recordation process for trade secrets. You can put them on your books and assign value to them. That helps, so if down the road an employee steals one, you have a lot of evidence that my litigator buddies can use to point to and say, look, it does have value. They're not just making something up. Having employees sign those type of invention disclosure documents shows evidence that they knew it was important, they knew it had value, they weren't taking something that was just retained technology in their head and moving it out. And those are pretty simple things that you can implement from day one. Thoughts on the other side?
No, I think you gave great guidance. I mean, we had so again, when I worked for a Mars family company, we would have certified trade secrets along this line, right? And so we would go through a process, an audit. We had a disclosure process because, as Danielle pointed out, the first time I was ever in a trade secret litigation, we got hit by two things. I'll tell you the second one is probably going to really freak some people out, and it goes back to NDAs. But in my experience, 90% of people, 90% plus of companies are getting this wrong. So the first one we got hit with was, so show us what your trade secrets are.
Yeah, and nobody can show. They don't have any paperwork. It's amazing.
Where's your list, right?
None.
We don't have one, right? The second thing that happened was this, and this is the one that's my personal beef with NDAs, because again, like I said, probably in my practice, I couldn't count how many of these I see, maybe even in a month. But most companies set these NDAs for a period of 2, 3, 4 years. Now, I'm not saying there's not some practical value to that. I don't remember what I was doing 4 years ago, and I'm sure a lot of other people here don't either. That being said, a trade secret, one of the greatest values of the trade secrets, for example, the Coca-Cola formula, the Google algorithm, ones that we know and love, that have been held up. And actually, if you're like, you can go on YouTube and see the KFC formula being shipped with the Black Hawk helicopters. Like, that's a good trade secret, right? Those have been powerful, right? Because they have not been copied for decades, right? Now, here was the second problem. How are you protecting it as a trade secret when 99% of your NDAs end in 2 years? Doesn't seem so confidential anymore. Great argument by the other lawyer.
Well, and that's getting to the point of NDAs. Like, we were talking in preparation for this panel about what are myths, and all NDAs are the same. I can't tell you how many clients tell me, well, I'm not going to send an NDA to you to review because, they're all the same. What's the difference? We'll sign yours, we'll sign theirs. How many people just sign any NDA that appears in front of them every day without ever thinking about it and barely read it? Thank you for the two honest people. Everybody else, I know you do it too. And they're totally not all the same. And he's completely right about thinking about the trade secret carve out. But in today's world, you also have to think about what is it saying about, the California Consumer Privacy Act is going to come into play in a couple months. What is it saying about GDPR? What is it saying about your data security practices? What is it saying about the retained knowledge so that you think you've got an NDA and it's really helpful, but gosh, there's a really nice residuals clause in there that kind of usurps and undermines it all. There are things in an NDA, it's not an end-all be-all. Just because you signed one, you're not safe. You should still be doing data minimization, share the least amount of information possible with the fewest people, and you really should have somebody looking at it or have somebody teach you how to look at it. It's not that hard to learn it if you have the right advisor to teach you how to do it, but you need to pay attention and think about them more than I think most people do. One of the big myths that I see, and it comes back to bite people in the ass, is they sign these NDAs where they just think they're covered, and then they have a problem, and the NDA is essentially useless.
But this is the reality. Oh, I'm so sorry. But the reality of trade secrets, in my opinion, is this. There's very few companies who can do it.
Yeah.
You don't have the discipline. I'm sorry. But I've been inside lots of companies. And it's a rare one. There are some out there that have the discipline. But it's very rare. And again, it may go completely contradictory to your corporate culture. And, know thyself is the beginning of knowing what you should do. If you are, an open company culture, you got tons of consultants floating around, people are coming in and out, you want to have this kind of innovation economy, right, where your network of other people, you are not a good candidate for trade secrets. You're going to lose. And any kind of illusion that you're building your house on that is nuts.
So you guys both bring up an interesting point, though. Most companies, unless they're IBM or Mars, who don't have a probably division worth of lawyers, you talked about the California Act that's coming up in a couple months. We had GDPR, obviously, in the last, 2 years. Mm-hmm. Keeping up with the laws, number one, is a challenge for your average company. Understanding how those laws affect existing contracts and, of course, how to apply it to future contracts is probably half, as difficult as just everything we're talking about as far as the applying and keeping track and keeping trade secrets. Keeping up with all of these changes for your average company is probably not very, simple for them to do.
Well, here's what I say to that. The underlying core principle to all of these issues, whether even trade secrets, I usually don't lump that in, but I think it fits, is sharing the least amount of information and retaining and taking the least amount of information that you absolutely need in order to run your business. And historically, the DNA of business in America has been gather all the information that you can, hoard it, keep it. Who the hell knows what we're going to do with it, but let's keep it all. I've got clients that have data, social security numbers, birth dates, home addresses of everybody that ever applied for a job from them since 1984. Seriously, I had a client that I counseled about that, why that was a bad idea. And they digitized it. They were really proud. They took all of the forms that they had in paper from 1984 and digitized it so it was electronically available. Great, right? No, it's not great. And they didn't even have any purpose for it. They just did it to create the data without thinking about what's the underlying business purpose. And you're right, you can't keep up with all the laws. But if you're doing what I'm talking about, if you're thinking about retaining the least amount of data necessary for you to perform your job and retaining it in a secure way, which goes back to Lynn's point about can you maintain the discipline to keep a trade secret secret? If you're building from the beginning of your company a DNA that says we value privacy, we value security, and we're building that into our business from the foundation up, that's going to set you apart. And I think that's going to help you down the road because that's where the future is going with these outside pressures from regulators and law. And I see it today in financings and in transactions. It's being used now as a pressure point to drive down valuations. Let me do the diligence. Let me see how you are maintaining those types of practices. And if you aren't, gosh, suddenly you're not as attractive as you were before. What's the real risk that you're going to have a breach that's going to impact on valuation from that? I think it's relatively small, but it's a great bargaining tool. And if you can stay on top of that as you grow your company towards the next exit, you're going to stand apart and you're going to be able to drive your valuations up higher.
We have time for about 3 questions. Anyone have any questions? Sir.
Is there any laws or best practices in terms of protecting your customer database? I know this now, but I used to run an organization. We had a contractor steal our customer database. There wasn't any protections in place. We then wrote them, but we lost. Well, I mean, they took 20,000 customer files.
Yeah, that's kind of a classic trade secret theft that you can't defend. Lynn was talking before about do you have a list of that as being a trade secret? Did you require the contractor to sign a paper acknowledging that they were going to have access to that trade secret? Did you keep value for it on your books? Did you only provide them access to the names on the list that they needed? Did you not give them read-only value? That's what I'm talking about, thinking about it from the structure at the beginning and building that kind of practice into the DNA of your organization. Those are the ways to protect yourself, and your experience is very common. Lynn said, you ask them, where's the evidence it was a trade secret? And there's absolutely no evidence. That's like 90% of the trade secret cases that I've seen. I don't know what your experience is.
Yeah.
But
Any other questions? Sir.
How challenging has China been with patent protection over the last decade?
Yeah, it's difficult. If you're spending money to get IP in China, you are betting on the future, to be blunt, and you hopefully have a good partner in country. Otherwise, you're probably wasting your time. One of the things I really enjoyed when I was a chief IP counsel was we'd bring different companies in to kind of collaborate on best practices every once in a while. And so we had the guys from Lego come in, and they just had their patent litigation in China, and they won. I mean, hands down. They got the police to actually go in and raid the apartment. There were 27 guys living in this apartment building fake Legos in a one-room apartment in China. Busted them. Probably spent $350,000 on the case. They got a $7,000 reward and a small print apology. Not good ROI. Right, so that's the kind of thing you got to think through. Is like, where are we doing this? What's the right venue? Right, the United States, Europe, those tend to be good shots. Again, China, big economy, right? They're certainly becoming more and more innovative. We'll have to see what that looks like in the future. But that's what you're doing. Certainly, for my startup friend over here, no, that is an utter waste of money. So,
One more question? Any more questions? Sir?
So for those companies that have a very open culture and very challenging, what are some other ways to protect, let's say, product development?
yeah, I mean, it's really lengthy, and I mean, I don't want to give you the lawyer. It depends, but it depends somewhat, right? It's who is the company? Who are the people, right? How tight do you have a hold on those folks? Again, we could get into hours of myths. We could talk about non-competes, right? A non-compete in Arizona is not very good. And Arizona is a favorable state compared to California or Massachusetts, where they're now illegal. So you have to, if you're going to use law to do it, you've got to think of different strategies and get a little unique and a little out of the box. Again, this is why patents tend to be somewhat useful if you're in the right industries because they're out and they're public. That's the downside and the pro side. Anybody who has ever feared their patent getting out is worried about, like, I just taught my competitors how to do things. And if you don't have a good patent strategy and a good patent attorney, yeah, that was really dumb. Don't do that, right? Because you did just give the recipe a way to do it. But that's why a lot of folks with that kind of culture, again, we do big audits for big biotech companies, and I just had this conversation with them. They're half based in Canada and half based in, let's just say, a very liberal American state. And I came in and told them, I said, guys, you know, you have this open culture. You've got a bunch of millennials, right? They all want to share and get out there and communicate with people. And in addition, you're in this terrible environment. You know, again, for you, thinking you have a good trade secret strategy is going to be very difficult. I love what Danielle said. If you want to do that strategy, you got to put it in your DNA and you got to live it. And have a good counselor around. So, like you said, it's so tough to know the law, but do what you're doing now, get some education enough, and realize as you grow, right, that's when it's going to matter. Lawyers are like sharks, right? We're going to be around when there's money. Trust me, when there's no money, we're not around because we don't really care, you know. But we're around when the money's around. So if you're small enough, right, you're probably flying under the radar screen, right? But when you're starting to get noticed, that's when you'll start to see us.
I guess the one thing I would say adding on to that is I have some clients that are very much focused on building open source community-based platforms. And in those organizations, I think there are some strategies that you can implement that require things to be donated to the community, require community involvement from the get-go. So it's kind of like building into the DNA the community, as opposed to building into the DNA the trade secret concept. And sometimes those can be done in tandem in different aspects. And so I think what's important is thinking about this as you're at the early stage. To change and pivot your organizational culture is very, very difficult. And so for young entrepreneurs starting out, I think they need to think about that with their founders, have that be part of the discussion, and then find the right people so that you grow the organization in a way that matches that strategy.
Maybe you don't need a patent. Again, Zappos didn't need a patent, right? They had something amazing. It was not patentable. They had the organizational diligence to hold that thing together. You know, if there are many assets besides patents, and again, I completely agree with my neighbor over here. A patent does not make a business. You know, it will protect a business. It's a ticket to sue people, and again, it's a way to value things, but it will not make your business at all.
Len, thank you for your honesty. We don't see that many lawyers these days. Ladies and gentlemen, please give him a round of applause. Thank you very much.